Thank you, Senator Welch. Senator Hawley.
Thank you, Mr. Chairman. Congratulations to all of the nominees. Thank you all for being here. Judge Bazis, if I could just start with you. I want to ask you about this case, United States versus Bartunik, I think it is, from 2017. Do you remember this case?
I do.
This is a case in which you granted pretrial release to the defendant. It was a child pornography case. Does that sound right?
Yes.
Now, you said in your responses to the panel's questions that the defendant had no criminal convictions and had lived in Nebraska his entire life, and that he owned the home he was living in and was employed. I understand, however, at the time that you granted him release, the Omaha Police Department had an open investigation regarding the sexual assault of a 7-year-old child in which he was the subject. He was the suspect, and that was in the pre-sentence report. So just walk me through your thinking.
During the hearing, I asked for additional information from the government, and they couldn't give it to me, so we didn't have a lot of facts in regards to that. The facts and circumstances, there was no additional information that was provided to me at that time.
So you didn't know he was the subject of the investigation?
There may have been a mention, but the question I had was, well, what does that mean? Has there been a report made? Is he truly the suspect, or was his name just mentioned? What were the circumstances? And at that point in time, there was no additional information that could be given.
I see. So it looks like to me what was, according to the revised PSR, the Omaha Police Department has an open investigation regarding the sexual assault of a 7-year-old child, who's then identified with initials, in which the defendant is the subject. But you're saying that you thought that was not sufficient in order to guide your judgment?
Was that the pre-sentence report, which would happen after sentencing, versus the pretrial report, which is what I would get prior to bond setting?
Offers the following objections to the revised PSR. The defendant objects to the inclusion of any reference, and then it goes on to quote this material about the sexual assault. So you're saying you didn't have that information?
Correct. That would have been after sentencing.
Okay, so you weren't aware that...
At sentencing, prior to sentencing after a plea, is when that information would.
Okay, so when you granted pretrial release, you were not aware that he was under investigation for the assault of a 7-year-old.
Based on what you're saying in that PSR, then no.
Well, I'm asking, is your memory any different? I mean, I can give these questions to you for the record if that would be more helpful. I just want to clarify the facts because I just want to make sure. If you're telling me you didn't know about it, that's a very different thing.
Well, I don't believe I did.
Okay.
But
okay. I tell you what, I'll give you some questions for the record on this, and that way, so that you don't have to just rely on your memory.
And I can go back and look at the pre-sentence report.
That'd be great.
Or
That
the
would be great.
pretrial report, which would tell me that.
Great, fair enough, thank you. Judge Meriweather, let me just ask you in my short remaining time here, I think Senator Kennedy was asking you about this case, United States versus Johnson, where you recommended the release of a sexual predator to get medical treatment. Is that right? Do I have the right case?
Senator, I recommended a 21-day a temporary release for medical treatment after holding multiple hearings and giving the government multiple opportunities to get Mr. Johnston to his appointments, because as I noted in the opinion, I thought the charges were deeply disturbing. I take very seriously the danger to the community, and I found when I balanced the 4 factors that I had to consider under the Bail Reform Act, that it was only his history and characteristics, which was that at the time that issue was before me, he had an urgent need for diagnostic and treatment, cancer treatment,
Let me just say, I'm sorry to interrupt you. I'm almost out of time. I just want to make sure I understand the sequence, because I might, as to my questions to Judge Bazis, I might not have the sequencing right. So just, you can correct me here. So I thought the government filed an emergency appeal of your release order, and you were overturned by the D.C. District Judge because, for among other reasons, the predator here had been caught in a sting operation. He'd admitted to sexually abusing his 8-year-old daughter. He had been previously court-martialed for molesting a child when he was in the Air Force. That child was his adopted daughter, and he claimed to have sexually molested other children, and the government thought that releasing him was a terrible idea. The district court agreed with him. Agreed with the government. So I just wonder, in light of all of that, as you look back on it now, do you think it was a bad decision to recommend release for him?
Two things. First, all of the abuse that it was alleged was horrific. The charges that were in front of me did not involve the molestation of his daughter, which I believe had happened 15 years earlier. And my decision was not based solely on the nature of the charges. That's but one of 4 factors that the Bail Reform Act required me to consider. The factual predicate, as I highlighted in that opinion, I found it very challenging to even entertain the idea of releasing someone charged with such heinous crimes, as well as someone who had a history decades earlier of abuse. But I found that his own interest in self-preservation paired with stringent conditions, being under the custody of his wife for a limited period of time and only allowed to leave his home to go to the doctor in order to get the timely cancer treatment that he needed, that despite 3 opportunities he was unable to get through no malicious intent of the government.
Can I just ask, this is it, Mr. Chairman, this is my last question. Can I just ask, I thought that he was getting cancer treatment, but your judgment was he wasn't getting enough or the right kind, but he was getting treatment. Is that not accurate?
No, that was the change between my ruling and the time of the reversal. I gave the government 3 opportunities to take him to the doctor, and I kept him detained despite it. He did not get to the doctor. I ordered him temporarily released so that he could see a cancer specialist, because cancer is a time-sensitive issue, as many of us know, with loved ones who are survivors of cancer. And then the next day, he got to the doctor. Had he been to the doctor, I would not have released him for 21 days. I didn't feel that he needed a specific doctor, which was the facts that were presented to the district judge. It was that he see any doctor so that he could timely have his cancer addressed. Unfortunately, that did not happen before he saw me, so I made the very difficult decision of ordering temporary release under stringent conditions so that could happen. It then happened, and so the need for it no longer existed. Had he seen the doctor before I ruled, I would have denied his motion, and I would have ordered that he remain detained.